Yes, this is Alice Waterman.
Good morning. I believe we have
Recording in progress.
Forum now, so we can get started. Good morning and welcome to the November 18th Victim Compensation Board meeting. Council, will you please call the roll?
Member Becton.
Present.
Member Silva.
I'm present. Having a technical problem here.
Do you need us to wait, Member Silva?
No, I'm present.
Thank you.
Had a issue. I'm good now.
Okay, thanks. Chair Ravel.
Present.
Item one is the approval of the minutes for the September 23rd, 2021 board meeting.
Is there any discussion, additions, or corrections to the minutes from board members? Seeing none, do I have a motion to approve item one?
I'll move to approve item one.
And a second?
I second.
Thank you.
Is there any public comment to the motion to approve the September minutes?
Seeing none, we can proceed to vote. Council, will you please call the roll?
The motion before the board is the approval of the September 23rd, 2021 meeting minutes. Member Becton.
Yes, approved.
Member Silva.
Aye.
Chair Ravel.
Aye.
Motion passes.
The next item is public comment. This is the opportunity for the public to comment on items that are not on the agenda. Any items discussed during public comment have not been agendized. The board is not permitted to take any action on these matters at this meeting. For those on the phone, if you previously indicated you desire to offer comments during this agenda item, we will be calling your name or by phone number. And for those participating by Zoom, please raise your hand if you wish to offer comment, and we will acknowledge you and let you know when it is your turn to speak.
Ms. Greer, I think we have someone with their hand up.
Yes. Yes. mjpetros@yahoo.com if you wish to speak.
Thank you. Good morning, board members and management. I would like to ask you to direct management to put a policy in place, if one does not already exist, to reply back to inquiries within a reasonable time, let's say 48 to 72 hours maximum. Both staff and management, in my opinion, cannot ignore voicemails or email messages. I would also like to ask the program to be more transparent with victims and the public on all decisions made on claims. Specifically, letters that go out to victims don't have the name of the staff person who made the decision or any contact information. I think that's very important to have, whether it's coming from the headquarters or the local victim witness offices at the counties. Victims and us as their advocates should be able to know who's making the decision and contact them directly. Not too long ago, I was told by a customer service at the 800 number that a claim specialist's name and contact information cannot be shared for security reasons. What security reasons? This program is here to serve the public, to serve victims, and you shouldn't be afraid of the clients, the victims. Lastly, I would really like to see more transparency in publishing statistics, not just numbers of files that were decided on and the dollar amount paid, but more details. For example, how many funerals and burials were submitted by individual victim witness offices as well as directly to the state? How many of them were paid? How many were denied? How many support loss claims for children versus the parents in murder cases? I would like to make comparison to the number of murders in the state and see if we really, as a state, are meeting the requirements and how many victims we're serving in the eligible categories. Thank you so much.
Thank you, Ms. Petros. Certainly appreciate that you want to hear from staff in an expeditious way. Oftentimes the issues are pretty complicated, and so it takes some time to look into them. But I understand your desire to have more frequent communication, and I appreciate your comments about transparency as well. And we will consider what we can do to implement the changes that you've requested.
Thank you.
Is there anyone else that would like to speak during public comment?
Okay, seeing none, I think we can move to our next item. Thank you.
Item 3 is the Executive Officer Statement, which will be presented by Executive Officer Linda Gledhill.
Good morning, board members, and welcome to the last board meeting of 2021. This year has flown by, and it's hard to believe that we're almost in the holiday season, but I have a few updates here for you at the end of the year. First, I'd like to welcome the newest member of our executive team, Sarah Ketch, who started on Monday. Sarah's our new Deputy Executive Officer for the Administration Division. She comes to us from Cal Recycle, where she held the title of Deputy Director of the Administration, Finance, and IT Services Division. She previously held the position of Chief Financial Officer at Cal Recycle for 6 years. And in her time she's there at Cal Recycle, she'd overseen almost every aspect of finance for the department. So she has great experience and has been a great addition to our team, and looking forward to having her be part of us as we move forward. As you know, the Cal Bcb staff has been almost entirely teleworking since the beginning of the pandemic. We had originally planned to bring staff back for a minimum of 1 day a week under the new telework policy at the beginning of September. We delayed that due to the need to acquire testing supplies and concerns about the Delta variant. We are now scheduled to return to the office weekly at the beginning of January. So I will have an update for you at our next board meeting. We'll see how the next 6 weeks go. Moving on, as we've discussed previously, legislation passed this year. Starting on January 1st, we will launch our forced or involuntary sterilization program. We've been working hard to get this program ready for launch, and you'll hear more about that in the contract report. This program provides compensation to survivors of state-sponsored sterilization conducted pursuant to eugenics laws that existed in the state of California between 1909 and 1979, and to survivors of coerced sterilizations of people in California prisons after 1979. And $7.8 million was appropriated for this program, with $4.5 million provided to directly compensate the victims. It's estimated that approximately 600 survivors of forced sterilization are alive today and would be eligible for this compensation. We begin taking applications on January 1st. We'll have more information on our website prior to that date. The program is scheduled to run 3 years to 2024. We are required to report annually on this program to the legislature, and you'll be hearing updates from me as well as we move forward. Lastly, as we approach the end of the year, and I am coming up on 2 years here at Cal Bcb, I wanted to take a look at our accomplishments and reflect and look ahead. The Cal Bcb Annual Report, which you have in your binder, covers the fiscal year from July 2020 to July 2021 and reflects a full year of my leadership at Cal Bcb. This report was posted on our website in October and is a snapshot of what we have accomplished. I wanted to share just a few highlights. We received more than 40,000 applications and made $52.7 million in payments for victims. We dramatically improved our efficiency. We cleared away a backlog of 13,000 unassigned applications and reduced processing times by more than 40%. We boosted our access and outreach through a new revamped website and reestablishing a Cal Bcb advisory committee. We also developed a strategic plan, updated our workforce strategic plan and created an employee recognition program to foster a culture of excellence. We also undertook several initiatives to keep employees engaged and committed to our mission while all navigating a pandemic and teleworking. I'm proud of what we've been able to do, but of course we have much more to do and look forward to talking to all of you about our plans for the new year in January. Happy to answer any questions that you have.
Thank you, Executive Officer Gledhill. First, I just want to welcome Ms. Keck. Really excited to have you here, and my colleagues who've worked with you speak very highly of you. So we think you'll just be a great addition to the team. I'm interested in hearing how the return to office goes starting in January. This is something that all of our state entities are dealing with in different ways, and so it's. I think we're going to have a lot of experimentation, and this is a new territory for all of us to be in this hybrid space. So I'm looking forward to hearing how that goes come the new year. Are there any questions or comments from the board? Okay, seeing nothing additional, I think we can move on to item 4.
Okay, item 4 is the legislative update, which will be presented by Deputy Executive Officer Andrew Lamar.
Good morning, board members. As you know, the legislature is out of session, but we do have a few updates on bill signings. Since the last meeting, the governor has signed SB 446, which changes the process for consideration of some erroneous conviction claims. Under the new law, we expect more erroneous convictions to be filed and paid. The governor also signed Budget Bill SB 170, which appropriates $300,000 for Cal BCB to contract with a Los Angeles-based community organization, the Alliance for a Better Community. The contract is to be for study and additional outreach to eligible claimants for the forced or involuntary sterilization compensation program. We're working with the Alliance to coordinate our efforts. Finally, the governor signed a budget trailer bill, AB 177, which eliminates administrative fees that fund the cost of collecting restitution. The Department of Finance has informed us that the state budget will include money for the entities that would lose funding from the eliminated fees, thereby supporting the restitution collection work done by those agencies. There are no other updates at this time. As I said, the legislature is not in session. They return to work early in January, so I'm happy to answer any questions if you have them.
Thank you, Deputy Lamar. I think you've all got your work cut out for you with these new bills, implementing them in the next year. It's a lot of new programs and new laws that BCB will have to implement. Is there any question or comment from the board on this item?
Is there any public comment on this item?
Okay, seeing none, I think we can move to our next item. Thank you, Deputy Lamar.
Item 5 is the contract update, which will be presented by Executive Officer Linda Gledhill.
Good morning, board members. First, I would like to remove one of the contract items. It's the second one listed in your binder under approval. So if you were going to pull that item for this month's agenda. So I'm going to present to you 2 other contracts for board approval. We're asking the board to approve are both related to the forced sterilization program that we've been talking about. The first contract is an interagency agreement with the Department of State Hospitals in the amount of $573,333.80. This contract runs from January 1st through February 29th, 2024. It will allow state hospitals to find and share records related to state-sponsored sterilization, which will allow us to help find and verify victims of this program. The second contract is for $280,000 and will run through 2023. This contract is for a vendor for our statewide outreach campaign related to the forced sterilization program. Some of the funds provided for this program were earmarked for outreach. The contract is currently going through the solicitation process and the terms and amounts listed in the contract report. Once complete, the contractor will be selected. Because this contract is set to begin January 1st, 2022, which is before our next board meeting, we're seeking your approval now. So I'm happy to answer any questions, but I'm seeking approval on the first and third items in your contract report.
Thank you, Officer Gledhill. It's still in this outreach contract is still in the procurement process, and you haven't selected a vendor yet.
That's correct.
Okay. Is there any discussion or questions from the board regarding this contract update? Okay, seeing none, do I have a motion to approve item 5?
I'll move to approve.
I second.
Is there any public comment on this item?
Seeing none, council, would you please call the roll?
The motion before the board is approval of items 1 and 3 in the contract report. Member Becton.
Approved.
Member Silva.
Aye.
Chair Rabo.
Aye.
Motion passes.
Okay, item 6 is the Penal Code Section 4900 claim of Sean Young, which will be presented by Chief Counsel Kim Gutierrez.
Good morning again. The claim of Sean Young stems from an application filed pursuant to Penal Code Section 4900 as an erroneously convicted felon with the Cal Bcb on April 15th of 2019. The application is based on Mr. Young's 2014 convictions for 7 counts of sexual assault of 3 minor victims, which occurred in 2013. The convictions were overturned by the state appellate court, and the case was remanded for retrial. On retrial in 2019, Mr. Young was found not guilty on all counts. The proposed decision recommends denying the application, as the hearing officer found that Mr. Young did not meet his burden of proof by a preponderance of evidence, showing that he was more likely innocent than guilty. Throughout these proceedings, Mr. Young has represented himself, and the Attorney General's office has been represented by Deputy Attorney General Jennifer Poe.
Thank you, counsel. We'll hear first from Mr. Young.
Mr. Young, it appears you're on mute.
Hello. Can you hear me?
We
Mr.
can.
Young, yes.
Okay. So I don't know. I guess I wasn't. First of all, I don't. I guess I don't really have anything to say that would make any sense to you all if you don't understand that being found not guilty means that you're not guilty and that you've been, wrongfully incarcerated for from 2013 until exoneration in 2019. A jury of my peers, the process that we're supposed to go through in the United States of America trials, and jury deliberations and verdicts. I don't know what more I can add. I don't know what burden of proof that I was innocent is needed other than the fact that the jury found me not guilty. I can't defend myself any more than was done in court, because it's the basis of me saying that I didn't do these things is I don't know. I'm at a loss. I really am. I don't understand why there would be a denial, but then again, I don't understand a lot of things that happens throughout this process, and that's it's frustrating. It's heartbreaking. It changes your life. I've been denied work because I'm still, for some reason, listed on the National Sex Offenders Registry, which I've taken up with the state of California and sent out the proof that I should not be on the National Sex Offenders Registry. And again, I've been denied employment because of that. And I haven't gotten a response from the state of California on that either. So, but getting back to the main apparent decision, I find it erroneous, and I find it harmful, and I find it very wrong, to say the least. I mean, these are the kindest words that I can use right now, because it's very clear to the jury, as well as to the people who know me and know that these things were not even possible in any way. But, you know, I guess I'm at the, I guess I have no real say in this. I don't understand what the preponderance of the evidence to my innocence could be other than a jury verdict, without me having videotaped my whole life that I spent with my children, who, by the way, I haven't seen or heard from because I don't have any contact, because my children's mother continues to be in hiding. So I haven't seen my children except for in court since 2013. So if you don't think that this changes your life in any way, and I'm not saying that money fixes that, not at all, but we have to hold the people who make mistakes accountable. And apparently that's not going to happen today. So I guess that's really all I have to say, other than I will, continue to claim my innocence. And it's not a claim, it's a fact. And I'm sorry that you all feel that this was not worth compensation.
Thank you, Mr. Young. We will hear now from Ms. Jennifer Poe of the Attorney General's Office.
I'd like to provide some reflection on the proposed decision, and I would encourage the board to adopt the decision of the hearing officer. The proposed decision is quite lengthy, and I was actually really impressed with the thoroughness of the presentation of the facts in this case. The hearing officer did a good job of laying out the facts presented, not only in the exhibits that were submitted by both parties and the entire record of the two trials that occurred in this case, but also the evidence that was admitted during the actual hearing. And the decision also accurately states the applicable law in this case and applies the law to the facts as they were presented, again, both in the written documentary evidence and at the hearing. And I think that there's a correct conclusion that the claimant has not met his burden. The facts of this case are, the decision in this case revolves around a credibility determination. And that's where the facts of this case really come into play and are very important to be considered. And then I will respond to the claimant's issue about the acquittal. The acquittal in the second trial for the claimant is not determinative. The burden is his to prove by preponderance of the evidence that he is innocent, which is a separate and apart from a determination that a prosecutor has not met his burden to show guilt beyond a reasonable doubt. And that's why the hearing officer in this case correctly determines that the acquittal in the second trial is not determinative. So overall, you have a proposed decision that it's been carefully crafted and it's responsive to all the issues raised by the claimant, both in his claim and at the hearing. And the Attorney General recommends that the board adopt the proposed decision and deny compensation in this case. Thank you.
Thank you, Ms. Poe. This is a troubling case and certainly not an easy one, but I will say I intend to support the staff recommendation here. for many of the reasons that have been discussed. I think the decision does a very good job, proposed decision does a very good job of laying out the issues, both with the burden of proof, as well as the distinctions between the earlier trial and the retrial that might have resulted in an acquittal. And the, as Ms. Poe said, the credibility determinations of the witnesses in the most recent proceedings. So I agree that in this claim, Mr. Young has not met his burden of proof to show factual innocence. Is there any additional discussion from the board? Okay, seeing none, do I have a motion on item 6?
I'd move to approve the board's decision, or I mean the hearing officer's decision.
Is there a second?
I second.
Is there any public comments on this item?
Seeing none, council, would you please call the roll?
Motion before the board is the approval of the proposed decision in the PC 4900 case of Sean Young. Member Becton.
Approve.
Member Silva.
Aye.
Chair Ravel.
Aye.
Motion passes.
Item 7 is the Penal Code Section 4900 claim of Alice Waterman, which will be presented by Chief Counsel Kim Gutierrez.
This claim stems from an application filed by Alice Waterman on April 25th of 2020 pursuant to Penal Code Section 4900 as an erroneously convicted felon. The claim is based on the 2014 convictions of Ms. Waterman for 6 counts of arson and one count of conspiracy to commit arson, 2 of which counts of arson were vacated by the Court of Appeal at the state level for insufficient evidence. The proposed decision recommends denying the application as Ms. Waterman has failed to show by a preponderance of the evidence that she is more likely innocent than guilty of her vacated convictions. Throughout these proceedings, Ms. Waterman represented herself, and the Office of the Attorney General was represented by Deputy Attorney General Barton Bowers.
Thank you, counsel. We will hear first from Ms. Waterman.
You're on mute, Ms. Waterman.
Can you hear me now?
Yes.
In this case, I'm not asking for the complete amount of money that I served. I understand that I was found guilty of some of the charges, but due to the appellate's decision taking so long, I was already released from incarceration when it overturned. So I'm only asking for money, the money of the days that I overserved my time, which was 465 days. So to me, if the appellate court has overturned 2 of my charges, that does show innocence of at least the 2 charges that were overturned. So, I don't understand why the board would deny the compensation of the days that I'm asking for. In the actual trial, there was no real evidence. It was all circumstantial. There was no DNA, no video, no pictures. There was nothing there. We've had in the trial, there were, in the transcripts of the original trial, there were investigation officers, captains of CAL FIRE, admitting that they changed the report because their superiors told them to fit my case. So to me, I am innocent. I know I am innocent, and I will continue to not deny that these charges. Basically, that's all I have. Thank you for the chance to talk.
Thank you for appearing, Ms. Waterman. We will hear now from Mr. Barton Bowers of the Attorney General's office.
Good morning. Can the board members hear me?
Yes, we can hear
The board
you.
members hear me.
We can hear you, Mr. Bowers, yes.
Very good. Chair Ravel, members of the board, the facts in the proposed decision are supported by the exhibits submitted in this case. The law set forth in the proposed decision is correct, and it is correctly applied. There is no other evidence that the board needs to consider to render its decision. So I am happy to answer any questions that the board may have, but otherwise I urge the board to adopt the decision as proposed. Thank you.
Thank you, Mr. Bowers. Yes, I'm in agreement with the staff decision on this one as well. I think, again, there's a burden of proof issue, and we don't really have any evidence aside from the denials. But is there any additional discussion or questions from the board on this item? Do I have a motion on item 7?
I'd move to adopt the hearing officer's proposed decision.
I second.
Is there any public comment on this item?
None. Council, will you please call the roll?
The motion before the board is approval of the proposed decision in the PC 4900 case of Alice Waterman. Member Becton.
Yay.
Member Silva.
Aye.
Chair Ravel.
Aye.
Motion passes.
Item 8 is the Penal Code Section 4900 claim of Guy Miles, which will also be presented by Chief Counsel Kim Gutierrez.
Guy Miles filed his application as an erroneously convicted felon with the California Victim Compensation Board on June 20th of 2019. This application stems from his 1999 convictions for 2 counts of robbery and 1 count of possessing a firearm. In 2017, the appellate court vacated all 3 of Mr. Miles' convictions. Upon remand, Mr. Miles pled guilty to 2 counts of robbery, and 1 count of possessing a firearm in exchange for time served. The proposed decision recommends compensation in the amount of $965,300, which represents $140 per day for each of the 6,895 days Mr. Miles was wrongfully imprisoned. Throughout these proceedings, Mr. Miles has been represented by Brooke Barnes of Procopia, Corey, Hargraves, and Savage. The Office of the Attorney General has been represented by Deputy Attorney General Barton Bowers.
Thank you, Counsel. We will hear first from Mr. Barnes, counsel for Mr. Miles.
Good morning, Chair Ravel and distinguished members of the board. It's a great pleasure that I'm here today on behalf of Mr. Guy Donald Miles. In this brief time, there is absolutely no way that I can capture what 6,895 days of spending in your days incarcerated in jail for being wrongfully convicted can feel like. That is an impossible task. There are only several people on this call that can even live to enunciate what this would appear and know better than Mr. Miles himself. But in this particular instance, there are 2 particular people that I should give great credit to, being the Deputy Attorney General, Barton Bowers, and his office, who over 2 years requested 15 extensions of time. I provided more than 3,000 documents to his office. Mr. Bowers met with Mr. Miles for several hours. He conducted many, many interviews, including over 7,000 pages of exhibits that he put forth to the board. Laura Simpton, the hearing officer, reviewed all of the evidence presented by Mr. Miles, as well as Mr. Bowers, and concluded what the appellate court found as well, that there is a ring of truth to Mr. Miles, and that he is not, in fact, guilty of the robbery that was committed in Fullerton. Mr. Miles has maintained his innocence at every step of the way. When the initial district attorney investigator met with Mr. Miles, he told him he was innocent. He certainly told his defense attorney that he was innocent. He told the prosecutor, Ms. Wook, that he was innocent. In fact, while he was on trial, he wrote the judge a letter, something that we attorneys know that is not often done, and told the judge he was innocent. When he was in prison for 18 years, he told everyone that would listen he was innocent. This was not because he thought he would get out of prison. This is because he was innocent. After several evidentiary hearings, Mr. Miles ultimately appealed to the Court of Appeal. There's interesting findings in the Court of Appeal's decision. One by Justice Moore that cannot be overstated, which is that Mr. Miles was only serving prison because 2 eyewitnesses identified him there. And we all know that eyewitness identification is subject to false identification. In fact, the 3 perpetrators admitted that Mr. Miles was not there. They all testified on his behalf. And those credibility determinations were found by the Court of Appeal to have a ring of truth to it and to be credible and trustworthy. In fact, the Court of Appeal found that had that been presented properly, that Mr. Miles would not have served any time in jail. So today, under the standard of 4905, we asked this board to approve what has already been conceded by the Attorney General's office and recommended by Ms. Simpson, which is that for Mr. Miles serving 18 years in prison for a crime he did not commit, or 6,895 days, he's entitled to compensation. I'm happy to review any part of the record or evidence any board members have, any questions. And again, it's a great pleasure that we're here today. Thank you.
Thank you, Mr. Barnes. Mr. Miles, would you like to address the board?
Mr. Miles, you're on mute.
Can you hear me?
Yes.
I really don't know what to say. This has been a continuous fight since I've been arrested for 19 years. Everything, I guess, has already been said, so I really don't have a lot to say. Thank you.
Now we will hear from Mr. Bowers at the Attorney General's office.
Thank you. Can the board hear me?
Yes, we can hear you.
Thank you. Hello again, Chair Ravel and members of the board. This is a relatively straightforward decision you have before you. I would simply urge the board to grant the claim. Thank you very much.
Thank you, Mr. Bowers. Let's start off the discussion just to recognize the serious injustice that Mr. Miles has suffered here. 18 years in prison is a very long time, especially under the circumstances. So I intend to support the proposed decision. Is there any discussion or questions from the board?
No question, but I agree with your comments, and 18 years is a really long time, and I do intend to support the decision, proposed decision.
Thank you. Is there a motion on item 8?
I'd move to adopt the hearing officer's decision, proposed decision.
And I'll second.
I second.
Is there any public comment on this item?
Seeing none, council, will you please call the roll?
The motion before the board is the approval of the hearing officer's proposed decision in the PC 4900 case of Guy Miles. Member Becton.
Approved.
Member Silva.
Aye.
Chair Ravel.
Aye.
Motion approved.
Thank you, council. At this time, the board is going to convene into closed session under Government Code Section 11126 sub C3 to discuss numbers 1 through 68B of the Victim Compensation Program. And board members, if I could please remind you to turn off your cameras and audio inputs before calling into our closed session line. Thank you. We'll reconvene shortly. Welcome back. We're ready to reconvene into open session under Government Code 11126 sub C3. I'd like to call for a motion to approve numbers 1 through 68B, except for 19A and B of the Victim Compensation Program.
So moved.
I second.
Thank you. Council, will you please call the roll?
Member Beckton,
Aye.
Member Silva,
Aye.
Chair Ravel.
Aye.
Motion passes.
Thank you, Council. Is there any other business that needs to come before the board today? Seeing none, I'd like to call for a motion to adjourn.
I move the meeting be adjourned.
Second.
Council, please call the roll.
Member Beckton,
Aye.
Member Silva,
Aye.
Chair Ravel.
Aye.
Meeting is adjourned. The next meeting will be January 20th of 2022.
Thank you all. Happy holidays.
Aye.
Recording stopped.